What's going on, YouTube? Listen up, young elder gang. This is Dr. Joe Blow at you with another banger. Please make sure you like, subscribe, and share this video, fam. I hope this video get at least 100,000 likes. In this video, you will find history, definitions, scripture, information, and best of all, what we Americans have been deprived of from the beginning, the truth. Keep in mind, this content used in this video is intended for entertainment, educational, and informational purposes only. We will give you the total truth as we best understand it today. Be sure to hit that like button, young elder gang. Hit that subscribe button if you're new to the channel. Hit that bell and don't forget to check back with us every day for new content. This is part 3 of the letter to Obama from the Pope. If you haven't checked out part 1 and 2, be sure to check out part 1 and 2 just below this video on the video side. So, how is this accomplished? Since the so-called military social government construct's bankruptcy in 1933, see America's New Deal, the looting of a nation, attorneys and judges have a near license to steal the wealth of the community backed by force of arm. They are amply rewarded for activities that promise nothing. They function at the heart of a system that has, as its ultimate goal, subjugation and conquest of the population through commerce. Although wars on the surface may appear to settle the differences between men and countries, it has been the behind-the-scenes manipulations by the bankers and merchants that continue to control. This was the case at the conclusion of their America's war for independence as it is now, not surprisingly mediated by attorneys, see A Brief History of United States. Attorneys do this with their own private language in which they change the popular meanings of words and embed the rules of the game inside inscrutable code. You can't play the game unless you understand the rules, and that takes an attorney. And even if you are one in a million, you are not allowed to use their private code to prosecute them for their thievery. Because such codes are copyrighted, there is no higher form of incestuous relations to prevent the people from the sheer bar to justice, established to prevent the money kings, by and through their agents, attorneys, from fleecing the people. One more fact is worth noting before concluding. The much ballyhooed and prestigious license to practice law does not even exist. See the Mythological license to practice law. There is no Department of State which issues said license, nor does the state bar in their alleged state exist other than as a corporation. You can prove this to yourself by going to the Commissioner of Corporations in their state. The so-called bar is merely a private club that collects union dues from its members, who posture as licensed professionals, which does not exist by and through any executive authority, governor's executive powers, of the so-called state, which issues all licenses to control supposedly every licensed professional. In summary, when you hire any attorney, you are underwriting the English crown to assign one of their unlicensed agents, learned in procedure not law, to animate a legal fiction, strawman, that was created on your behalf. There is misrepresentation by and through centers of education to accept such contrivances as legal. When you were born, they bring you into their slaughterhouse to argue your case, thus giving meaning to the legal fiction they have created there. Hence, subject matter jurisdiction gives rise to a cause of action whether legally or not, while transferring as much of what you presume is your wealth as they can get away with. Then it is hoped that you will come back for more, on appeal. A sucker is born every day, and they know this because they educate them to remain born suckers. Is this what you thought you were bargaining for? Every so-called state in the Union has laws on their books forbidding the unauthorized practice of their law. This fact alone might lead one to conclude that being a licensed member of the legal professional is not only required, but that one not so duly appointed had better not even think about offering legal writings or advice without having a license to practice law. To test this assumption, we go to California, the so-called Union's most populous so-called state, our test subject to see how they do it, California style. Whereas the notion of a license to practice law is scarcely mentioned in state and federal codes, the requirements relating to every other kind of license in existence is spelled out in mind-numbing detail, for example vehicle code, internal revenue code, etc. The sacred license to practice law, however, remains undefined. Answers to questions regarding where it comes from, how it is conferred, where one goes to see what it looks like, its tenure and its cost remain elusive like the wind. These and other intensely pertinent questions remain unanswered by the codes that imply its existence. To be certified to the Supreme Court for admission and a license to practice law a person who has not been admitted to practice law in a sister state. Every person on his admission shall take an oath to support the Constitution of the United States and the Constitution of the State of California, and faithfully to discharge the duties of an attorney at law to the best of his knowledge and ability. A certificate of the oath shall be endorsed upon his license. Attorney with obligation to the courts and to the public, not to the client, and wherever the duties of his client conflict with those he owes as an officer of the court in the administration of justice, the former must yield to the later. Emphasis added. Corpus Juris Scandium, 1980, Volume 7, heading, Attorney-Client, Sections 2, 3, and 4. C note. All attorneys owe their allegiance first to the Crown of England, second to the courts, third to the public, and finally to their clients as wards of court. Is it any wonder your attorney never wins a case for you? BAR, acronym for British Accreditation Regency. Look up each of these words. Attorneys are members of the bar. The American Bar Association is a branch of the Bar Council, sole bar association in England. All laws today in America are copyrighted property of a British company. All state codes are private, commercial, British-owned law. All attorneys follow instruction from England to turn, twist and turn over their clients to the private law of the bankruptcy. That is their job. That is their pledge to those whom they owe allegiance. As such, and from time and time again, reliable sources, including attorneys, reveal that law has no bearing on what happens in court proceedings as much as the procedure of which is only known to BR members. Judges, prosecutors, attorneys, including the very defense attorney you were gullible enough to use, hire, or who was compelled upon you, who carefully and methodically extract either all your time, community service/slave labor, money, bail, liens, levy, garnishment, fine, restitution, property, child, home, car, bank account, or your liberty, detention, jail, prison, probation. No one told you that your attorney can only represent your debtor, an artificial person entity. No one told you that court proceedings are purely administrative and not judicial, as the organic constitutions, state and federal mandate. In these administrative proceedings, why is it that these so-called courts do not explain the nature and cause of the action, never prove jurisdiction, and never allow you to have counsel of your choice, and never ever allow the jury to decide the law in a case trial? Maybe those administrative tribunals are not constitutional judicial courts of due process. Welcome to America. What is a privateers? A privateer is a private individual or ship that is commissioned by a government to engage in maritime warfare during wartime. Privateers were a key part of naval strategy in the past, allowing countries to project power at sea without having to pay for large navies. Here are some things to know about privateers. A sovereign or delegated authority issues a commission, also known as a letter of marque, to privateers. This commission gives the privateer the right to attack foreign vessels and take them as prizes. Privateers receive a portion of the money from the sale of the goods they seize from enemy ships. Privateers are required to follow the laws of war, treat captives well, and avoid attacking neutrals. Privateering has a long history, dating back to the Middle Ages. It was a major part of the American Revolution and the War of 1812. The main difference between privateers and pirates is that privateers are commissioned by a government, while pirates are not. Great Britain and other European countries outlawed privateering in 1856, but the United States continued to use them until the end of the 19th century. Spain outlawed privateering in 1908. A privateer is a private person or vessel which engages in maritime warfare under a commission of war. Since robbery under arms was a common aspect of seaborne trade, until the early 19th century all merchant ships carried arms. A sovereign or delegated authority issued commissions, also referred to as letters of marque, during wartime. The commission empowered the holder to carry on all forms of hostility permissible at sea by the usages of war. This included attacking foreign vessels and taking them as prizes and taking crews prisoner for exchange. Captured ships were subject to condemnation and sale under prize law, with the proceeds divided by percentage between the privateer's sponsors, ship owners, captains, and crew. A percentage share usually went to the issuer of the commission, that is the sovereign. Privateering allowed sovereigns to raise revenue for war by mobilizing privately owned armed ships and sailors to supplement state power. For participants, privateering provided the potential for a greater income and profit than obtainable as a merchant seafarer or fisher. However, this incentive increased the risk of privateers turning to piracy when war ended. What is a practice in law? The practice of law is the application of legal knowledge and judgment to a person's circumstances or objectives. It involves a variety of activities, including representing clients, acting as a client's representative in court, administrative proceedings or tribunals, providing legal advice, giving legal advice or counseling to clients, preparing legal documents, drafting, selecting, or preparing legal documents that affect a client's legal rights, managing legal proceedings, commencing, negotiating, or disposing of civil or criminal legal actions, advising non-lawyers, counseling non-lawyers who want to proceed pro se. The practice of law is a professional service that can be performed by lawyers, barristers, solicitors, or civil law notaries. However, the practice of law overlaps with other professions, such as banking, real estate, insurance, and accounting. The definition of the practice of law can vary by state and is often fact-specific. For example, in Maryland, the practice of law includes advising on probate, preparing real estate title instruments, and preparing documents filed in court. In its most general sense, the practice of law involves giving legal advice to clients, drafting legal documents for clients, and representing clients in legal negotiations and court proceedings such as lawsuits, and is applied to the professional services of a lawyer or attorney at law, barrister, solicitor, or civil law notary. However, there is a substantial amount of overlap between the practice of law and various other professions where clients are represented by agents. These professions include real estate, banking, accounting, and insurance. Moreover, a growing number of legal document assistants, LDAs, are offering services which have traditionally been offered only by lawyers and their employee paralegals. Many documents may now be created by computer-assisted drafting libraries, where the clients are asked a series of questions that are posed by the software in order to construct the legal documents. In addition, regulatory consulting firms also provide advisory services on regulatory compliance that were traditionally provided exclusively by law firms. What is a volunteer? In law, a volunteer is someone who performs work for a public agency or organization without expectation or receipt of compensation. A volunteer is someone who performs work without expectation of compensation. Volunteering can include driving for the Red Cross, working with children, or helping with a youth program. Individuals can volunteer for public agencies in their community, but public sector employers cannot allow their employees to volunteer without compensation. Volunteers can be reimbursed for expenses they incur while volunteering. Volunteers can come and go as they please, and their roles are often ill-defined. However, if some consideration is given, the individual may be considered a worker or employee and may acquire employment rights. A person who gives his services without any express or implied promise of remuneration in return is called a volunteer and is entitled to no remuneration for his services, nor to any compensation for injuries sustained by him in performing what he has undertaken. Under your own free will, in law, means that a person is making a decision or taking an action without any form of coercion, duress, or undue influence. Essentially, they are choosing to do something voluntarily and of their own accord, without being forced or manipulated into it. Key points about under your own free will. It signifies that a person has the ability to choose between different options and is not being compelled to act in a specific way. This phrase is often used in situations where consent is crucial, like signing a contract, making a confession, or giving legal testimony. If someone claims an action was not taken under their own free will, the burden may fall on them to prove that they were coerced or influenced improperly. If a person signs a contract under their own free will, it means they understood the terms and were not pressured or tricked into signing it. What is flagrant breach of trust? A flagrant breach of trust is a breach of trust that is so obvious that it is shocking. The adjective flagrant means something is extremely bad or shocking in an obvious way. Synonyms of flagrant include egregious and glaring. A breach of trust occurs when someone breaks the rules of a trust or takes advantage of property that was given to them for a period of time. For example, a trustee may breach a trust by using the trust's assets for their own benefit, such as by making unauthorized withdrawals or selling trust property without permission. Beneficiaries of a trust may be able to seek monetary damages or other remedies if they believe that a trustee has breached the trust. Serious breach of trust means either a single act that causes significant harm or involves flagrant misconduct, or a series of smaller breaches, none of which individually justify removal when considered alone, but which do so when considered together. Some examples of a breach of trust include distributing trust assets to a beneficiary who is not entitled to them, investing the trust fund in a way that is not permitted, selling one of their own assets to the trust, commingling personal funds with trust funds, favoring one beneficiary over another, accepting a bribe or kickback, managing the trust assets in a negligent or bad faith manner. Beneficiaries may be able to seek monetary damages or an equitable remedy for breaches of trust. Members of the bar associations are required to seize and desist assaults against the American states and American state citizens and shall be subject to arrest, confiscation, and deportation otherwise. Pope Francis sends Obama in so much as corporate officers operating in the United States of America, Incorporated, and the United States have contrived under conditions of fraud and semantic deceit to revenue the estates of the American states and live an American state citizen. To the foreign jurisdiction of the United States of America minor, they are found guilty of capital crimes, including acts of fraud and treason committed between 1933 and 1945, and are condemned posthumously. What does cease and desist mean? Cease and desist is a legal term that means to stop and refrain from repeating an unlawful activity. It can refer to a cease and desist letter or a cease and desist court order. A cease and desist letter is a document sent by one party, often a business, to warn another party that they believe the other party is committing an unlawful act, such as copyright infringement, and that they will take legal action if the other party continues the alleged unlawful activity. The letter may warn that, if the recipient does not discontinue specified conduct or take certain actions by deadlines set in the letter's recipient may be sued. The phrase cease and desist is a legal doublet made up of two near synonyms. A cease and desist letter issued by a government entity called a cease and desist order is a warning of impending judicial enforcement, a formal request to stop an activity that is harmful or illegal. The letter is a warning that legal action may be taken if the activity continues. It's often used to protect intellectual property rights such as copyrights, trademarks, and patents. Cease and desist letters are usually written by attorneys. Cease and desist court order, an order from an administrative agency to stop an unfair labor practice or method of competition. If a person doesn't comply with the order, they may be found in civil contempt. What is assaults? Assault is the act of causing or threatening to cause physical harm or unwanted physical contact to another person. It can be committed with or without a weapon, and can range from physical violence to threats of violence. In law, assault is the act of intentionally causing someone to fear imminent physical harm or offensive contact. Assault can be the threat of violence, or the attempt to inflict harm. The victim must reasonably believe that they are in immediate danger of harmful or offensive contact. The actor must intend to cause the victim to fear harm, even if they don't intend to actually cause harm. The actor must be able to carry out the act that would result in force being applied. Assault is both a crime and a tort, which means it can result in criminal prosecution, civil liability, or both. The punishment for assault varies depending on the type of assault and other factors. For example, a fifth-degree assault is a misdemeanor, but if the same victim is assaulted again within 10 years, it becomes a felony. Assault is often referred to as an attempt to commit battery, which is the act of actually physically harming someone. In many places, assault and battery have merged into one charge. In the terminology of law, an assault is the act of causing physical harm or unwanted physical contact to another person, or in some legal definitions, the threat or attempt to do so. It is both a crime and a tort, and therefore may result in criminal prosecution, civil liability, or both. What is treason? Treason is a crime that involves attempting to overthrow a country's government or helping its enemies in war. A person who commits treason is known as a traitor. In the United States, treason is defined in Article 3, Section 3 of the Constitution. It includes levying war against the United States, giving aid and comfort to enemies of the United States. A person cannot be convicted of treason unless there is testimony from two witnesses to the same act or a confession in open court. The punishment for treason in the United States is death, or at least 5 years in prison, a fine of at least $10,000, and the inability to hold any office in the United States. Treason refers to the betrayal of one's own country by attempting to overthrow the government through waging war against the state or materially aiding its enemies. In so much as elected officials operating in the United States of America, minor, have similarly committed war crimes against the American states and their peaceful inhabitants during the same time period, they stand condemned posthumously. No enforcement upon any American state or American state citizen is owed as a result of any act of any Congress operating as the sovereign government of the United States of America, minor, nor as the Board of Directors or Board of Trustees. Any incorporated entity whatsoever. All those estates and estates erroneously believed to represent the American states and American state citizens, and which were conveyed by fraud and legal deceit to the United States of America, minor, and more recently to the city-state of the United Nations, are revenued without exception to the geographically defined American states and the American state citizens, where they shall remain in perpetuity as assets belonging to the rightful and lawful beneficiaries. What is the sovereign government? A sovereign government is a government that has the right to self-govern a nation or group of people and is not subject to any other political entity. Sovereignty is the legal term for the authority of a government to govern its people and land. A sovereign nation is a nation whose government has supreme authority over its population and territory. The United States, each state, and Indian tribes are all sovereign entities. Limitations. While the concept of sovereignty is relatively easy to define, it can be difficult to identify and understand in practice. For example, in the United States, state laws may differ from federal laws, but federal laws always trump state laws. Sovereign citizen movement. The sovereign citizen movement is a far-right anti-government movement that challenges the legitimacy of the government. The movement originated with Christian identity minister William Potter Gale in 1971. Sovereignty is the right of a nation or group of people to be self-governing. We speak of countries such as the United States as being sovereign political powers because they are completely independent of any other political entity. What is incorporated entity? An incorporated entity is a business that has been registered with a state as a separate legal entity from its owners, also known as shareholders. The term incorporated is often abbreviated as Inc. Incorporation brings with it legal obligations and benefits, including legal obligations. Incorporating a business requires filing articles of incorporation with a state agency and adhering to legal obligations such as tax filings and annual reports. Legal benefits. Incorporating a business provides limited liability protection for shareholders, meaning their personal assets are protected if the company is sued or incurs debt. It also allows the business to own property, enter contracts, and engage in business. Raising capital. Incorporating a business allows the company to issue stock and sell it to raise funds. Incorporation can be more complex and costly to establish and maintain than other types of businesses. The state of incorporation's laws will govern the internal affairs of the company. Examples of incorporated entities include Apple Inc. and Microsoft Corporation. Incorporating a business can offer several advantages, including limited liability. Shareholders' personal assets are protected if the company is sued or incurs debt. Tax benefits. Corporations can deduct employee benefits, real estate investments, and more on their tax returns. Ability to issue stock. Incorporating allows a business owner to sell ownership stakes in the company. Incorporating a business can be complex and costly, as it requires adhering to more regulations, filing paperwork such as articles of incorporation, keeping detailed financial records. Some other types of incorporated businesses include limited liability company, LLC, S corporation, C corporation, general partnership, limited liability partnership, and limited partnership. What is limited liability? Limited liability is a legal principle that protects shareholders and owners from personal liability for a business's debts and losses. It limits the amount of money an owner or investor can lose to the amount of money they've invested in the business. Limited liability is available for corporations, limited liability companies, LLCs, and limited liability partnerships, LLPs. In contrast, sole proprietors and general partners have unlimited liability, meaning they are personally liable for all business debts. Here are some benefits of limited liability. Protects personal assets. Investors' personal assets are protected from the business's debts and losses. Encourages investment. Limited liability encourages investors to buy equity in companies because they're not at risk of losing their personal assets. Separates finances. Limited liability allows businesses to keep their finances separate from the owner's personal finances. However, there are some exceptions to limited liability, such as the doctrine of corporate veil piercing. This doctrine allows courts to hold investors personally liable if a corporation engages in egregious actions, such as mixing personal and corporate assets. What is the Board of Directors and Board of Trustees? A board of directors is typically used for for-profit companies, overseeing business operations and representing shareholder interests, while a board of trustees is usually found in non-profit organizations like charities or educational institutions, focusing on managing assets and upholding the organization's mission, often with a stronger emphasis on fiduciary responsibility towards beneficiaries. Board of directors prioritize financial performance and shareholder value, while boards of trustees focus on fulfilling the organization's mission and serving the community. Directors are typically elected by shareholders, while trustees may be appointed by founders or donors. Liability: trustees may be held to a higher standard of fiduciary duty, potentially liable for acts of simple negligence, unlike directors who usually only face liability for gross negligence. What is a trustees? A trustee is a person or entity that manages assets for the benefit of a third party called the beneficiary. Trustees are legally responsible for carrying out the wishes of the trust's creator or grantor and acting in the best interests of the beneficiaries. Trustees are typically appointed for trusts, but they can also be appointed for other purposes such as bankruptcy, retirement plans, or to manage assets for a minor. Some responsibilities of a trustee include managing assets. Trustees are legally responsible for the trust assets and must keep them separate from their own. They should invest assets prudently and maintain adequate insurance. Distributing assets. Trustees must distribute funds to the beneficiaries according to the terms of the trust. Filing taxes. Trustees are responsible for filing tax returns and keeping financial records organized. Communicating with beneficiaries. Trustees should answer questions from beneficiaries and provide them with statements and account information. Acting impartially, trustees must treat all beneficiaries equally unless the trust states otherwise. Trustees are held to a high standard and are expected to act in the best interests of the beneficiaries at all times. If a trustee dies, resigns, or is removed, the court will appoint a new trustee to take their place. What is estates? In law, an estate is the total value of a person's assets minus their liabilities and can refer to a living or deceased person. Assets includes all property, investments, and other entitlements such as real estate, personal property, cash, and insurance. Liabilities includes debts like credit card debt, car loans, and mortgages. Significance: estates are legally important in the context of bankruptcy and death. Estate taxes may be levied on the value of an estate at death. The term estate can also refer to the possessions of someone who has died and are subject to probate, the assets managed by a guardian for a ward or by a conservator for a conservatee, a real property interest such as a life estate or estate for years. Estate planning is the process of managing how assets will be transferred to beneficiaries after someone passes away. Trusts are often created as part of estate planning and can be used to provide for a surviving spouse. An estate is the total property, real and personal, owned by an individual prior to distribution through a trust or will. All legal fiction entities, however, structured and named after the American states and American state citizens, are returned to them and their control free and clear of any debt, promise, encumbrance, or obligation alleged against them as a result of false claims made in their behalf by officers of the United States of America, Incorporated, and the United States Incorporated, or by any foreign officials operating in the United States of America, minor, or the United Nations city-state, falsely claiming to represent them or have jurisdiction over them. We note that the current circumstance is in part the result of criminal acts engaged in 150 years ago, which resulted in the commercial enslavement of so-called African Americans, who were summarily claimed as chattels backing U.S. government debt in wake of the Civil War, and reclassified as Black Negro and colors and subject the Black Christian Code. What is legal fiction entities? A legal fiction is a legal construct that assumes something is true even if it is not, in order to apply a rule in a way that is different from its original purpose. Legal fictions are used to fill gaps in the law, resolve uncertainties, or adapt the law to new situations. Here are some examples of legal fictions. Treating a corporation as a person. Corporations are treated as people for many purposes, allowing them to enter into contracts, sue and be sued, and own property. Quasi in rem subtype 2 jurisdiction. When a court cannot exercise jurisdiction over a defendant, it can use this legal fiction to bring the defendant under its jurisdiction by using the defendant's property to satisfy the claim. Constructive trust. A court creates a constructive trust over assets they determine a party cannot equitably keep. Legal fictions are different from legal presumptions. which assume a certain state of facts until the opposite is proved. A legal fiction is an assumption and acceptance of something as fact by a court, although it may not be true, to allow a rule to operate or be applied in a manner that differs from its original purpose while leaving the letter of the law unchanged. Reasons for creating a legal fiction can vary, but legal fictions are typically designed to achieve convenience, consistency, equity, or justice. The federal corporation. What you will come to understand, learn, and know is that the United States, the federal corporation, went bankrupt in 1933, and as a result of further acts, removed the substance backing our nation's money, replacing it with bankruptcy script of a private corporation called the Federal Reserve Bank. Sometime in the 1960s, the Uniform Commercial Code, UCC, was adopted by most all states. The UCC is the federal common law of negotiable instruments and governs all transactions because there is no lawful money, substance backing the money being gold and silver, therefore you have not paid your bills nor paid for anything pursuant to the law of payment since 1933. All you have ever done is discharge the debt until a future time, but you have not obtained title. The government, because of going bankrupt, had to finance its operation to survive, and it needed to do so because it can only tax what it creates. It created artificial entities, ens legis, being a corporation or trust corporation, so that it could tax it, and in doing so, sends you the tax bill or other presentments for fines, fees, and taxes. In operating this scheme against you, you think the presentment is in your name. The government has divested you of your rights, titles, interests, property, and wealth by and through an undisclosed and non-disclosed commercial program to rape, pillage, and plunder the American. In June 1933, the international bankers, owners of the Federal Reserve Bank, a private bank, took control of all private and real property by the consent of Congress due to the United States Inc. going bankrupt in 1933 and as supported by executive orders of the then presidents and upheld by preceding presidents and Congress as well. As a result of these acts, Congress made provisions for redemption in the 1900s for your reinstatement of rightful status as an American sovereign when you became of age or became aware of the right to redeem. These provisions were placed in various acts, legislation, resolutions, and executive orders, mostly in and around 1933, including but limited to HJR 192, which has since been codified in Public Law 73-10, and so confirmed by the United States Supreme Court in 1939. The United States Supreme Court, as at present constituted, has departed from the Constitution as it been interpreted from its inception, and has followed the urgings of social reformers in foisting upon this nation laws which even Congress could not constitutionally pass. It has amended the Constitution in a manner unknown to the document itself. While it takes 3/4 of the states of the Union to change the Constitution legally, yet as few as 5 men who have never been elected to office can by judicial fiat accomplish a change just as radical as could 3/4 of the states of this nation. As a result of the recent holdings of that court, the sovereignty of the states is practically abolished, and the erstwhile free and independent state are now in effect and purpose merely closely supervised units in the federal system. The first thing that was done was to make an entity which looked and sounded like the forms of government to which the people of Earth were familiar with, such as the Federal Republic entitled United States of America. Notice that the U in United is a small u. That's because it is an adjective describing the states, noun, of America. What if one capitalized the U, as in United States? This would be a name, a title, wouldn't it? So now we have a title for the Republic which was incorporated in England in 1871 as an English corporation. So does this mean we are being ruled by a private, foreign-operated corporation, not a government? Has this happened to most other such governments on planet Earth?